You are welcome to Business Law 1 class. Today we look at Section 4 of Unit 6, the definition and types of product liability. By the end of this session, you should be able to describe the following: the nature and the definition of product liability, the types of product liability, the theory of product liability, lastly, the common defense to product liability. Now, when you talk about product liability, you are referring to a manufacturer or seller being liable for placing a defective product in the hands of the consumer. So, either the manufacturer or the seller placing a defective product in the market, whereby people purchase it and consume. So basically, you are saying that where the manufacturer produces goods that is unhealthy or defective, now if the consumer purchases that product and consumes, and he or she suffers injury or falls sick, then the manufacturer will be responsible for placing that goods in the market or selling those goods to the consumer. Perhaps after the manufacturer has produced, the seller also altered the goods in some way before the consumer bought it. In that case, the seller too will be responsible or be liable for the injury caused to C. Now, you should understand that you have different types of defects. Under the theory of liability, a plaintiff in a product liability case must prove that the product that caused injury was defective. So you have to prove that the product is defective and that the defect made the product unreasonably dangerous. So because of the defect, the product was unreasonably dangerous, that it had a tendency of causing harm to the final consumer. Now, there are different types of defects. So we are considering the three types of defect and a product liability. The first one is design defects. Design defects. And this normally deal with the container or how the product has been packaged. If the design caused the injury, like the can, if you don't do it well and it causes injury, it means that the product is defective. The defect it's not only related to the product itself, but the container or the bottle as well. If that one causes injury, that one too, it means that you'll be held liable for product liability. So the manufacturing defect, it has to do with the product itself. When you were producing the product, you failed to exercise due diligence and some animals on unhealthy item went through the product. And when that one caused injury, as a producer or manufacturer, you'll be held responsible. Marketing defect. Here, the law requires that give warnings where you produce product or when you are advertising product and you think that there are certain things that you have to put across before so that the public will be aware when they are taking those goods. For instance, cigarettes, you see that they have written inscription, it will cause harm to you. Now, if they fail to give that description and people buy the cigarette, it constitutes a marketing defect. And all that defects, the consumer can sue the manufacturers for product liability. Now let's look at the theories of product liabilities. Say that the product liability is based on three theories: warranty, breach of warranty, negligence, and strict liability. With breach of warranty, this is what you are saying. If someone buys product from you and you give the person one that you can use this product within 2 years, it will not spoil, and this is assurance. Now, if the person go and within 2 years, the thing fails to perform. So he has given you that you have a warranty of at least 2 years. Now you use it 3 months and the thing has spoiled. You can sue the person for breach of warranty. You also have negligence. One, by the producer's negligence, something unhealthy gets into the product and the final consumer consumes and he or she is injured as a result of consumption of the product. You can sue the manufacturer for negligence. That's the manufacturer had a duty of care to ensure that the product is a healthy form, and he breached that obligation by failing to ensure that that one has been done, and the damage has been caused to the final consumer for consuming the item. So you can sue the manufacturer for negligence. Straight liability. Here, once you produce the item, you expect that if it is not altered and you intend that it should reach the final consumer as it is, then any injury that will cause to the final consumer after taking it, the manufacturer will be held responsible. So the liability is strict. No, it is not negotiable. So as we were explaining, as I explained the product liability in terms of the first theory, that is the theory concerning the failure to fulfill the terms of promise, claim or guarantee or presentation made about the product, and it can be express warranty, that is expressly stated by the seller, implied warranty of merchantability, implied by statute, implied by warranty of fitness. This one too is implied by statute. There's implied warranty that the goods will fit for the purpose in which it was bought for. The second theory, as we indicated, negligence. So with negligence, you have a duty of care and you have failed to exercise a duty of care. In that case, all those within the product line may be held liable. The designer, the manufacturer, the distributor, or the seller, based on the role that you play in the ensuring that the goods get to the final consumer. The seller might have altered the product in some way. Then he or she will be responsible. So depending on the role that you play in to ensure that the goods has gotten to the final consumer, it will determine whether you were negligent or not. You also indicated straight liability. So we are saying that this means that a business will be held liable if defective product causes injury, regardless of fault. So this one, you don't care about whether you are at fault or not. Once the breach or the injury has been caused, you will be liable. So this usually happens when the liability is created by statute. So when the statute creates those liabilities, you can't negotiate it. Now you also have what we call the unavoidable unsafe products. These are the products that is very sharp and you have to or capable of committing or causing injury. So you have to give proper instructions. So by their nature, some products simply cannot be made cannot be made safer without losing their usefulness. So for instance, a knife that is too dark to injure anyone would also be useless for its intended purpose. That's why it is sharp. So it needs to be made sharp before it can be used. It's a general belief that as to such products, users and consumers are the best equipped to minimize the risk. So if you buy those products, the users and the consumer, you have to be careful when you are using it, as it will harm you. This requires a proper warning to be given to avoid any liability. So if you sell dangerous products or poisonous substances, you have to give warning to avoid liabilities. Now let's look at the defenses to product liability claims. We are saying that a defense often is raised in product liability cases is that the plaintiff has not sufficiently identified the supplier of the product that allegedly caused the injury. So if you're not able to identify the supplier of the product, you cannot sue, because you have to identify the person who brought the product in the system. There's an exception to this rule, and which is known as the market share liability exception. And it simply said that each manufacturer will be held liable according to the percentage of sales in the area where the injury occurred. So if you are manufacturing at one particular locality where the injury occurred, then you all be responsible to contribute to the injury based on your percentage of the shares of that particular area you hold. Another defense is that the plaintiff substantially altered the product. And here a typical example is those male and females who purchase body cream and they mix the cream with other creams. Those products, when you mix them and they cause injury to your body, you can't sue anyone. The manufacturer can use as a defense against you because the chemicals that you have mixed has possibility of causing damage to your body. If you use one product, I think there will be low possibility that the injury might have occurred. Also, a related offense is when you misuse the product. You buy drug and they say use it one at a time because you are suffering. You take 7 at a go. When it causes injury to you, it's your own fault. The manufacturer will use it as a defense against you. By way of summary, we have thoroughly and successfully gone through what product liability means, 8 types, theories, I illustrate liability, the common defense to the product. Thank you and have a nice day.